Welcome everybody. Welcome to another one of our webinar series on evolutions in whistleblowing and what federal contractors should really know given some of the regulatory and statutory changes that have happened over the past few years and continue to get strengthened. My name is Sai Alba. I'm a partner in our government contracts group, and I'm here with...
Hi, good afternoon. I'm Sarah Nash. I work with labor and employment here.
And so, again, thanks to everybody for coming, and everybody already knows about us. So what we're going to talk about today is a few different things. First, there's been a number of developments going forward through different acts. The National Defense Authorization Act that comes out every year. In 2013 and 2016, there have been some changes and additions to whistleblower protections. The Defend Trade Secrets Act, that's relatively new, has some additional protections. The False Claim Act has certain protections within it that aren't necessarily new, but have gotten more press recently, more importance given the focus on whistleblower protections. And then, of course, I just want to note that we all know, I'm sure we've been listening to the news and things, of the VA whistleblower protections that just went into effect that the president signed recently. Those don't have a large impact on contractors per se. A lot of it, as far from the whistleblower perspective, a lot of it was reiterating or re-strengthening some of the protections and letting the VA know specifically that Congress and the president are sort of watching, and we want you to do a better job, VA. And the rest of it, more of the changes that are a sea change, go to how federal employees are protected and treated, not in the whistleblower contracts, but generally. So there's not really a lot to go into that we're not going to already talk through the NDAA, Defense Trade Secret Act, and False Claims Act issues as to whistleblowing in the new act. Then we're going to talk about how some of these laws apply directly to contractors, what you need to be thinking about, and then also compliance strategies, best practices. So, how do you incentivize employees to report internally first so you can do other investigations if there's an allegation of wrongdoing or some false claim issue? Preferably, you would want that to be reported within the company, and then the company perform an investigation and make a determination as to the veracity, credibility of the allegations, and then make a disclosure as necessary. So we'll talk through some of that stuff as well. And to start off, we're going to go through the National Defense Authorization Act and some of the changes.
Great, thanks, Sai. So Sai mentioned that the NDAA, as we'll call it, has had several iterations over the past few years. Most recently in 2016, they extended a pilot program that was put into place under the 2013 Act. And what the pilot program did was it extended whistleblower protections to civilian contractors. And it took that beyond the DoD defenses that were in place for DoD and NASA contractors, and kind of strengthened those protections and put them into a permanent place. So what we're going to look at here is just some of the ways that whistleblowers are protected under these relatively new laws, and look at pointing out ways to prevent whistleblower retaliation claims and keep contractors sort of covered from those sort of issues. These two laws under the NDAA apply to both DoD and NASA, and then civilian contracts. And most recently, it was extended to personal service contractors as well. And not only does it stop there, but it covers subcontractors and any grantees or subgrantees. So essentially, what Congress was looking to do was to protect federal funds that might be going towards contracting, and just make sure that those funds are protected from waste, fraud, and abuse. There are certain exceptions, however, under the Act. They do not apply to intelligence community agencies. So the FBI, CIA, NSA are not protected. Those contractors are not protected. So you have people like Edward Snowden, or more recently Reality Winner with the intelligence about Russia's alleged interference in the election last year. Those contractors remain unprotected under the Act for understandable concerns with certain intelligence information you don't necessarily want out in the universe.
And the only other thing I'd add is that there are protections, internal protections within those agencies that are followed or allegedly followed at certain times. Now, obviously, with some of these people who did these leaks, they would argue that they had tried that or thought about trying it, and that those processes and procedures weren't really followed, and they were at risk for retaliation. But there are procedures within there as well. It's not like there's no protection for these sorts of whistleblowing, but you have to go through the proper channels, obviously, and not, to the Washington Post or something like that.
Right. Obviously, you don't want classified information going to the Post. Perhaps you can submit that to an IG. Which brings us to our next slide, sort of ways that reprisal is prohibited. So these are, as a contractor, you are prohibited under the NDA from retaliating against employees who make protected disclosures. And what does reprisal mean? It's anything that's likely to sort of chill or dissuade an employee's speech or disclosures. So if you're going to fire someone, demotions, if you're going to transfer them maybe far away from their current post, reassignment, harassment. In some cases, courts have even found that litigation can even be retaliatory. These are things that are not protected or that are prohibited under the Act. And one kind of neat thing about the NDA, which is different from other whistleblower protections, is that this reprisal is prohibited even if it's undertaken at the request of the customer. So in government contracting world, that's going to be the agency. So even if an agency says, we don't want this employee around, that's considered retaliation or reprisal. Now, there is an exception if for some reason there's a non-discretionary directive that essentially takes it outside of an individual's discretion and makes it a requirement of the agency. In those situations, I would argue it's not really reprisal to begin with, but they have written an exception in those cases. So those are the sort of things that are considered reprisal under the Act. Now, what is protected? A whistleblower's disclosures are protected if a whistleblower reasonably believes that there is evidence of any of the below 5 categories. You have gross mismanagement of a contractor grant, gross waste of funds, abuse of authority, substantial and specific danger to public health or safety, or a violation of law, rule, or regulation. Let's break those down because that kind of covers a lot of material. First, a gross mismanagement. This is an action or inaction which is likely to jeopardize the mission or objective of a contract. So if you've improperly staffed a project or you're ignoring an integral responsibility, these might be considered gross mismanagement. Now, this is more than just a disagreement about policy matters. It must be a serious error in judgment. And you can't always tell, but I'll just reiterate that it has to be a reasonable belief. So it's not really going to be reasonable if the contractor decided to go with one brand or over another. That's not reasonable that they were exercising gross mismanagement necessarily. Next, gross waste of funds. It sort of speaks for itself. The idea that you might spend, I don't know, $20,000 replacing a table that's not even broken. These are the sort of things that an IG might be looking for. Abuse of authority, any arbitrary or capricious exercise of power that adversely affects someone. Harassment might be an example of this. Intimidation. Providing preferential treatment to an employee who a supervisor had an intimate relationship with. These are examples of how this is an abuse that probably should not be going on and someone in government should be notified. Lastly, or second to lastly, substantial and specific threat to public health. It sort of explains it in its words. It must be substantial and it must be specific, which means that there is a likelihood of harm resulting from a threat. It can't just be some remote possibility. For example, there's arsenic that's been released into drinking water, and I have an example of this. These are substantial and specific. And lastly, a violation of rule, law, or regulation. These have been, at least in other whistleblower provisions, read very broadly. There's no de minimis exception. Any violation of law, as long as it's reasonable, is protected.
And just one of the other things, like to add, we understand, I'm sure you guys are picking up on this well, like some of these things, management action or inaction or gross waste of fund, gross mismanagement, arbitrary capricious exercise of power, these things are all sort of legal definitions of things and would be hashed out in a court or some sort of administrative proceeding if, somebody tried to complain that they were terminated or moved or harassed or something like that based on a whistleblower claim. And it's not really easy to make a determination up front whether the type of action that's being alleged by the employee and what you might be doing to a particular employee is based on their complaint that would be protected or based on something that was going to happen before. Let's say you have a bad employee who's doing a terrible job, the government wants them off the job, and then they're kind of wise to some of these things and they start making complaints, and then you're sort of stuck. And so I would say if you're in a position where it's not crystal clear, to either talk to the advice of counsel, your in-house counsel, if it's someone within the agency counsel, to try to talk to them about whether or not, what the risk level is, whether or not the behavior here meets those standards or not. Because if you're on the line, erring on the side of caution and just trying to work with the person and working towards, if you were going to terminate the person anyway, making sure things are crystal clear that this was the intent, and frankly, preparing for a possible lawsuit or something like that is likely, and it's the person's right to take that sort of action. It's unfortunate, but it is what it is.
Exactly, and I'll just reiterate here that even if, let's take gross waste of funds, even if there hasn't been a gross waste of funds, if a whistleblower reasonably believes that there has been, that's still protected. So you still can't retaliate against someone just because they have a mistaken belief, which sort of complicates things a little bit. Sometimes it feels a little bit unfair. But remember, these laws are drafted to protect whistleblowers, not necessarily to root out fraud, but to protect people who are looking for fraud to begin with. Just as there are limits on what a whistleblower is protected to disclose, there are limits on to whom a whistleblower may disclose this information. The NDAA has fairly broad descriptions of who may be the recipient of whistleblower disclosures. This includes anyone from Congress to an inspector general of an agency, the Government Accountability, which is basically the watchdog for Congress, an agency employee responsible for contract oversight or management, an authorized official of a law enforcement agency or the DOJ, a court, or anyone within the contractor who is a management official responsible for investigating this sort of misconduct, so an HR manager or even a CEO in certain circumstances.
Yeah, and we'll get into a little bit later about the last bullet there. Like, that's from a company perspective, that's your preference, is that any employee brings something to your attention so you can investigate, you can verify the veracity of the statements, the credibility, and do an investigation and make a choice about what you need to do as a company. It gives you much tighter control on things, obviously avoids embarrassment, other problems, things of that nature. And there's nothing improper about that. If you're incentivizing employees to do those sorts of things, use your internal procedures, that's just fine. It's the punishment aspects that are prohibited.
Exactly. And also making sure that you're not keeping or preventing employees from going outside the contractor to share these sort of disclosures. So what happens if there is a whistleblower who believes that they have been retaliated against? What the NDAA does is it provides a couple of avenues for them to take advantage of. One, they can submit a complaint to the agency inspector general. The inspector general will then investigate the allegations, and assuming they're not frivolous, will recommend specific remedial actions to the agency head. So this is sort of a scary route, because instead of going to the contractor, they're going to the agency head, who is essentially your customer in this matter. So it can get kind of ugly. All of a sudden your personal affairs are out there, and the head of the agency is looking at them. Alternatively, if the agency head, for whatever reason, denies relief, after a certain amount of time, the complainant can take their whistleblower retaliation claims to a federal district court for de novo, just a fancy legal term for looking at something from a fresh perspective review, and litigate their claims there. Assuming that an agency head does find that there was a wrongful retaliation, they can order a few different remedies. One might be that the contractor stop the reprisal. They can order reinstatement of someone who's been terminated with back pay, any compensation they might have received, any employment benefits. This might include not only health benefit costs, but also perhaps they would have been promoted at some point. So it just focuses on a make-whole remedy for employees. They can also order the contractor to pay the whistleblower for any costs and expenses associated with their whistleblower claims. This includes attorney fees, which can be quite high, and expert witness fees, transportation fees, medical fees, anything that the whistleblower essentially suffered because of the retaliation. These claims can get quite high, and so it's nice to avoid them if possible.
What are the GAO reports?
Yeah, so one fun thing about when you have pilot programs before Congress, like the 2013 NDAA did, is the GAO will often be tasked with sort of reviewing the pilot program. And recently in March, the GAO came out with a study that kind of evaluated where the pilot program was. And I guess the most straightforward way to put it is they weren't that impressed with the work that agencies had done, even though agencies, they looked at, I think, 14 agencies, even though they look at about 1,500 whistleblower reprisal claims over that period, only 127 of those claims came from contractor employees. So one way to look at that is to say, well, that's great. Contractors aren't retaliating against employees who are disclosing fraud, waste, and abuse. The more likely explanation is that employees aren't aware of these protections and aren't aware of their rights under the new NDAA standards. So GAO is looking to encourage agencies to improve the way that it's notifying contractors and employees of these rights. And not only that, but of the 127 complaints that were submitted, only 44 of those were actually investigated. So the GAO, at least in their study, is recommending that agencies put a higher priority on investigating these kinds of complaints. So even if employees haven't been making disclosures in the past, over the past few years, it's pretty clear that Congress or the agencies are going to look to get more complaints in the future. So this could become a bigger issue as more employees learn about their sort of protections.
Yeah, another thing too, just based on those numbers, we just went through some of the remedies that the agency heads can enforce, but based on that GAO report, it seems like such a small fraction of these claims are actually investigated, or not super small, but say a quarter of them are investigated, and that just doesn't really incentivize contractors to be incredibly diligent about these kinds of things if they're just going to be able to sort of fire people or somehow harm individuals who make whistleblower claims. And I think that's also, like Sarah was saying, that's where the GAO is sort of keyed in on that too. And I think there tends to be an assumption within the government that the government is doing everything right. It's the contractors that aren't doing things correctly. And I think that's sort of borne out in the GAO report, because they're looking at what they can do to, like Sarah said, inform employees of what their rights are, so that, because the reason there were so few complaints in their mind is that people didn't know enough, and they would have complained more had they known. And by the way, then if they know their rights and they're more forthcoming, that would make it easier to investigate, and that would increase the investigations on retaliation claims. And so the idea from GAO is that the numbers are really much higher and sort of being hidden by the lack of information, not the assumption that the reverse is true. Whereas from the government perspective, there's a presumption generally that everyone acts in good faith. And so there's this belief that the government is doing everything correctly, and they don't necessarily dig in as much as I think they probably should. So take that for what it's worth.
So there are a few kind of miscellaneous noteworthy provisions that apply to contractors, agencies that have been included in the NDAA. One is that you can't gag employees. There's no waiver provision. And what this means is that you can't, for example, have a settlement agreement or a confidentiality agreement that waives an employee's right to blow the whistle. This has become pretty standard in most whistleblower retaliation protections. You can't prohibit someone from whistleblowing. Even if you've reached a settlement with them in their whistleblower claim, generally they have to be permitted to speak truth to whatever government agency might be experiencing fraud. Next, there's also notice requirements, which essentially requires that you notify employees of their rights under the NDAA. They have a right to make disclosures, and they have a right to be protected from retaliation for making those disclosures. And the law itself also makes clear that you have to provide this notice in the predominant native language of the workforce. So if you have a Spanish-speaking workforce, you better have somewhere where you explain in Spanish that these employees are protected by whistleblower provisions of the NDAA. The DoD's version of the NDAA also has a requirement that you post IG hotline posters, that essentially these posters are prominently displayed somewhere where employees can look at them and reference them, just making sure that they know who to call if they notice fraud with the DoD. And then lastly, unallowable costs. Typically, contractors are used to getting reimbursement for any maybe cost that you might spend on a contract. The law itself specifically precludes reimbursement for legal fees incurred by contractors for whistleblower retaliation claims. Now there's a caveat that it has to be a meritorious whistleblower retaliation claim, and there has been, at least in practice, an exception for settlement discussions. So they want to encourage the contractors to play well with others and speak with the whistleblower and recognize if they may be wrongly retaliated against someone.
Yeah, and if you're familiar with how various costs, internal costs and external professional fees, legal, accounting, etc., are treated when you're in a REA versus a claim, it's very similar to that. So REA costs, whether they're legal, accounting, or internal, are generally allowable because the idea is that you're negotiating with the government and in good faith and trying to settle a dispute outside of litigation. And that's the same general idea that flows through here. They're trying to incentivize people to settle without litigation. And if you go to litigation, just like if you scrap an REA and file an actual claim, then all the legal, accounting, other professional fees, and internal costs are no longer recoverable or allowable. So they have to be excluded. And it's not just that they're not directly recoverable, like they have to be excluded from your overhead pools, your G&A pools, all of that sort of thing. So any costs for these sort of whistleblower retaliation claims should not be included in there if they're meritorious.
And the same goes for whistleblower actions under the False Claims Act as well. We'll talk about a little bit about the False Claims Act in a little bit. Also, just be mindful that these NDA protections are incorporated into FAR and DFAR clauses, and they're supposed to be included in solicitations that are posted from agencies. We have here in this slide a list of where you might find these FAR clauses.
And the other thing that's interesting, though, that the GAO report mentioned is that a lot of agencies aren't including these clauses in their contracts, and that was something that the GAO kind of slapped down the agencies on and said, these clauses should be incorporated and they should be there all the time. There's a question about, there's something called the Christian Doctrine, which is based on a case, Christian v. U.S., that years ago, that said that if there's a required regulation FAR clause that should be included in a contract and isn't, by just mistake or negligence of the government, then it's impliedly included and read into the contract. I don't know of cases where these sort of protections are actually Christianed in, as they say, into the contracts, but it's likely, given the statutory basis for these and how they're required clauses in various circumstances, that a court would probably read them in. So if there was some sort of retaliation claim that a employee would bring to the agency and potentially through a court against you, it's also possible that that could turn into some sort of termination action or a bad CPAR rating or potentially termination for default, which could then result in suspension, debarment. Now, I've never seen that happen. That's probably a stretch, but it's possible that those sorts of things could happen. So just be aware, even if it's not in your contract. Highly recommend following the statutes.
So that concludes our sort of mini rundown of NDAA's requirements. Next up, we are going to discuss Defend Trade Secrets Act of 2016, which also went into effect last, I think it was March, where the focus of this act is not necessarily whistleblowing, but as has been the trend, Congress injected whistleblowing protections into the act, which just shows how much Congress loves talking about whistleblowers. They love their whistleblowers. What the Defend Trade Secrets Act does is it essentially creates, I'll go to the next, it provides a federal legal cause of action to private companies for trade secret misappropriation. And this doesn't really change the protections. Most companies are protected under state causes of actions, but what it does is it unifies everything. So now you don't have to go to state court to enforce these rights. You can go directly to federal court, which is kind of a nice benefit. And it protects it has a pretty wide definition of trade secrets. Any forms of business or economic, engineering, financial information that you might have that you consider valuable, that you've taken reasonable measures to protect, is considered a trade secret. And in addition to providing these protections for company trade secrets, they also have this whistleblower immunity and anti-retaliation provisions that are intended to protect individuals who might need to disclose trade secrets through disclosing information to either a government official or an attorney for investigating some suspected violation of law. They can even use trade secrets, for example, if they've been retaliated against and they want to somehow show that they lost their job due to wrongful termination of retaliation. So there's a few, essentially, I guess you could call them loopholes in the Act that protect disclosure of trade secrets where they are disclosed by a whistleblower.
And when you're talking about copyrights or things of that nature that are sort of officially designated types of trade secrets, patents, those sorts of things, if somebody is disclosing, say, source code, right, because they said it's put in there to I don't know, fleece the government somehow, and they're reporting you, and as part of that they reveal the source code. The whistleblower is protected from disclosing it to these certain entities and individuals, and generally speaking, you have to protect your IP rights, and if you fail to protect it, then you can lose those rights entirely. And while this is too new, this act is too new to see if there's any cases on this, I would think generally that a court would be sympathetic that you can't retaliate against the employee to protect your IP rights if they've disclosed to these people. But you need to pay attention that if you think an employee has disclosed trade secret information either to the government, their own private attorney, they've done something in a complaint or some other forum that's appropriate, to watch and make sure that those trade secrets stay contained in whatever that cause of action, whatever that forum happens to be. Because if, let's say they disclose it to an attorney that's their private attorney who has a friend who runs an IT company who's in the same line of business, and he just happens to lose the source code one day and it shows up in his friend's inbox or something like that, you would still have to enforce your rights against that other individual. And so it might make sense to be a little bit more vigilant than usual if you know about certain information that's a protected amount of information under the Trade Secrets Act, or you have copyright or patent, whatever, that information has a higher potential for leakage outside the company. And while you can't retaliate against the individual, you should be more vigilant protecting that in the broader community.
Right. And I'll also add that it's sort of broad because it protects any violation of law. You might recall from the NDA, we talked about violations of law related to the contract itself. However, here it applies to any violation. So you could have an ingredient in some restaurant's secret sauce and the employee thinks, hey, that's a violation of some FDA regulation, I'm going to report it. The nice thing is that it's a very limited list of people. It's less likely that this is going to make it out into the public forum to kind of ruin your trade secret, as it were. The sort of part about the Defend Trade Secrets Act that applies to most employers, at least employers with trade secrets that they really want to protect and might consider going after someone for disclosing or wrongfully using their trade secret, is the notice requirement. And like the NDAA, the Defend Trade Secrets Act essentially requires that you put employees on notice that they have certain immunity and retaliation provisions that protect them for whistleblowing. And it's not a huge deal if you don't include these protections or these notice requirements, but if you don't include it, then the employer, you can't recover punitive damages or attorney's fees under the Defend Trade Secrets Act. So suppose an employee of yours takes your trade secrets, takes them to, I don't know, their attorney for some reason or whatsoever. Actually, no, they don't even take them to your attorney. They take them to some competitor. If you go after this employee and you didn't have these protections in your employee handbook or the employee agreement that you might have signed with this employee, you can't get punitive damages when you apply the ND or the DTSA to this case. Of course, this doesn't apply to state claims. Those are still available under state claims. You can get punitive damages or attorney's fees. It's just not under the federal law. And that's sort of how the government incentivizes employers to include this language. Just another indication that Congress really likes whistleblowers. This brings us to everyone's favorite fraud legal sort of framework, the False Claims Act.
And so, the False Claims Act obviously is a much broader statute and comes up in many contexts, but it's one that is, I think, particularly susceptible to whistleblower retaliation issues because there's a lot of emotion in these sorts of things, because a lot of times, in fact, the vast majority that we see here of False Claim Act claims come from disgruntled employees. And sometimes it's employees that were terminated for completely legitimate reasons. Sometimes it comes from employees who were terminated and even went to jail for the conduct, that like defrauding a company or embezzling funds, things of that nature. They get out of jail and they file a qui tam action, right? And they keep pushing these sorts of claims, and companies just are flabbergasted by that kind of thing, because how can somebody pursue some claim and potentially enrich themselves through a qui tam action if they stole money from us, or if they were just an absolutely terrible employee and almost made us lose a contract, or did make us lose a contract because of their performance, and then they turn around because they have knowledge of some unrelated issue, file a qui tam case, and make a couple $1 million off of us. It's just really infuriating. But the sort of knee-jerk reaction to go after them or to attack needs to be tempered a little bit if there's any potential for a retaliation claim. If the person is filing the qui tam action and they're doing it and there's some good faith basis behind it, then you need to treat it as a legitimate FCA complaint. If the DOJ starts investigating, go through that whole process. But to file a counterclaim or to take some other action, if you didn't terminate the employee, if you took them off the contract, and let's say they had a relationship with someone on the contract, now they don't see that person anymore, and they're pissed, and they file some qui tam action, and they're still your employee, you need to be very, very careful how you treat that employee, what you do, even in basic reviews, or how you speak to the person, how the person's treated in the office. It really heightens the level of tension there. And I found that most False Claims Act are just full of emotion, and it's hard to separate that sometimes, but you really need to focus on that as a contractor.
And I'll just add that when it comes to whistleblower laws, timing is really everything. And if you engage in some sort of reprisal, or whether it's reprisal or something else, maybe you just didn't like the employee, you wanted to get rid of them. If you do this right after they file a False Claims Act qui tam lawsuit, like 9 to 10, a court would find that you retaliated. It makes it really easy to prove retaliation if any negative employment action follows directly after an employee blew the whistle. If you're going to do yourself a favor, if you really can't live with this employee, at least wait, 3 months, 6 months before you do anything drastic. Yeah. So we're talking about the False Claims Act. It didn't have any big new item tickets in it this past year, but because it's everyone's favorite law, we thought we would talk about it. It applies to contractors more than most whistleblower cases, protections anyway. Last year, just to give you some fun statistics about the Act, the government recovered $4.7 billion in damages from the False Claims Act, and of that, $2.9 billion came from lawsuits filed under the qui tam or whistleblower provisions of the FCA. That is a lot of dollars, and there's a lot on the line when False Claims Act petitions get filed. 702 qui tam lawsuits were filed in 2016. That works out to about 13.5 cases a week. That is a lot of allegations of fraud and abuse that's being alleged. and these payouts are huge. Some of the big ticket industries include healthcare, financial services, housing and mortgage, and the fact that these numbers keep on going up, I think 4.7 was the third highest annual recovery ever. The fact that these numbers are going up show that people are thinking more and more about whistleblowing. It's in the media, it's in the press, it's in our sort of films, pop culture. People are thinking about whistleblowing. It's going to become more and more of an issue going forward.
I'll say too, just from our experience with smaller companies, I mean, every now and then you'll have a situation where there's some investigation that comes directly from the government. Like, I don't know if people have seen the movie War Dogs, but like that kind of scenario where there's falsity on the part of the contractor that's then discovered within the government. DOJ starts an investigation, and then a criminal action or civil action occurs out of that. In the sort of small to mid-sized business or even other larger contractors, it tends to come out of qui tam actions by employees, the vast majority of them. And so it's something to, or former employees, something to just be aware of. So whenever if you're talking about regulatory compliance issues and you're trying to figure out what you should do, and let's say you contact your attorney or in-house counsel or even have a meeting internally with executives, if there's anything discussed that, even if it was just accidental, that could implicate some sort of violation or question of violation, try to keep that group of people as limited as possible, because you don't necessarily want to bring in someone who's not the most trusted, at the top tier trusted individual, because if something were to happen to them in the future, they essentially have ammunition to bring you. And the statute of limitations on these things is 6 years basically after the final invoice. So if you're talking about, a 5-year contract and something might have gone wrong in year 1, you've effectively got 10 years before you can sort of rest easy. So something to think about.
And Sai mentioned statute of limitations. When it comes to retaliation against employees, I believe it's whatever state law controls, typically maybe 3 years. So even then, someone can bring a retaliation claim 3 years after they've been terminated. So this stuff is always kind of haunting you. You want to make sure that you abide by whatever proper protocols up front so you don't have to worry about this down the line. The FCA's anti-retaliation provision, it's pretty broad. I think it was expanded in 2009. It protects not only employees, but contractors and other agents as well from being discriminated against, discharged, demoted, suspended, harassed, go through that whole list of reprisal. Anything that's supposed to chill these employees and keep them from sharing this information is prohibited. And it's any discrimination because the individual investigated, reported, or tried to stop a company from engaging in fraud against the United States government. It's pretty broad. The government wants to stop fraud. The remedies here are similar to other whistleblower retaliation laws. However, there is double back pay. So instead of just owing an employee lost wages, you owe twice the lost wages. Not only that, but unlike the NDAA, special damages might include non-economic harm, emotional distress, pain, and suffering. These can rack up really quickly, especially in these emotionally charged situations, which Sai talked about. FCA is especially emotionally charged. So when you have people's reputation on the line, their career, their entire life's work, you can imagine how these numbers can add up really quickly. And you also have attorney's fees and costs.
Yeah, and I had a client about a year ago who was asking about some of the attorney's fees questions here. And a lot of FCA claims that come through qui tam actions are taken on contingency. There's basically a whole group of the bar that basically does contingency cases under qui tam actions. So in that case, what the client, employee who you might be facing is being billed is like zero. And you might get your first subpoena in like 2012, and then you might get some follow-up in 2014, and then there might be discussions with DOJ in 2015 and 16, and they might go quiet for another year, and then it's quite costly, and the employee is most likely paying nothing, especially because all they really have to do is fire off a complaint, and then the government investigates and kind of takes over from there. And what's interesting about the attorney's fees provisions is that these contingency fee lawyers have some billable rate that they have written down somewhere, and they will keep track of these and how much time they're spending and calculate all that. And even though if they lose, they wouldn't get a dime, if they were to win or if you go to settle, then they're going to pull out that spreadsheet or bills that they've created and say, well, these are the fees, which is somewhat of a misnomer because nobody actually owes that amount of money. The contract between the attorney and the employee was that they get some percentage, most likely, of whatever's recovered. And if like literally nothing's being recovered or only a fraction of it, but then they refuse to settle the case until all their quote-unquote attorney's fees are covered that aren't really billed or billable fees, people have been very frustrated. I have clients that get very frustrated at that, and it's just sort of part of the situation. So you should just be aware that that's the way these things are calculated.
Especially if you get as far as discovery in the world of email and just online documentation, you can easily, I heard of so many situations where the attorney's fees are actually more than what back pay would have been to begin with, which it just seems like a ridiculous. But that just shows you how much Congress really likes whistleblowers. They want to make sure that they have incentives to bring these cases forward. So we've discussed sort of 3 laws that are particularly applicable to contractors in the federal contracting world. However, this is but a drop in the bucket of the many, many, many whistleblower provisions that exist out there in the federal government. You have anything from protections for disclosures about food and water safety to environmental threats or risks, toxic substances, consumer products, motor vehicles. Pretty much you name it at this point, there is a whistleblower anti-retaliation provision out there that Congress has taken under its wing. And that this doesn't even begin to mention the many state whistleblower laws that are also out there. I say this only because if you work in a certain industry, so if you work in finance, for example, the Dodd-Frank Act might apply, and you should always be considering if an employee has brought information to you or to an outside party that might be considered protected disclosures under some sort of whistleblower statute, think twice before you act. You always want to investigate and make sure that you're not terminating someone, because this is an exception to the at-will employment general rule, whistleblowers protection in general. So before you just get angry and fire someone off the bat because they're saying something you disagree with, make sure that what they're saying isn't protected under one of these many laws. And I'll just add that all of the sort of internal workings of these whistleblower statutes vary. Most of them are enforced by the Department of Labor, their OSHA department, but they all vary when it comes to different statutes of limitations, which particular individuals are protected. Sometimes they even consider independent contractors in addition to employees to be protected. So you just want to make sure that you understand the different nuances. Obviously, we don't have time to go through them today, but maybe in a future webinar we can touch on some other fun examples. So this brings us to the fun problem-solving side of this webinar. How do you avoid, knowing now that these laws exist and that these protections exist for whistleblowers, how do you go forward without, one, making sure that your dirty laundry isn't put out there to the public or to your contracting officer, or two, making sure that you're not bit later on for retaliating against a protective whistleblower? first and foremost, you want to encourage a culture of compliance and make sure that employees understand that you are not a company that retaliates against whistleblowers. Seems sort of obvious, but you don't know how many times I've read a handbook that essentially says employees can't discuss anything about the company anywhere regardless of the consequences. That sort of thing isn't going to fly in this world. So first, you want to make sure that employees have a secure and a reliable way to report any suspected violations, and you want to make sure that they do this internally to the company. How do you let employees know that this is a sort of preferred way of disclosure? You tell them in company handbooks, company policies, employment agreements. There's no harm in just even having staff meetings where you remind employees of their that the company encourages them to make these disclosures internally. You can set up a third-party hotline if you're in that sort of situation where you have many employees that might want to disclose aspects about company workings anonymously. And you want to make sure that you're training your supervisors and managers in how to recognize complaints and report if they hear something that is non-compliant or that is a violation of law. You want to make sure that this gets up to the top so that you can actually do something about it. Make sure that you have an open door policy and that employees feel comfortable taking these pretty much any way inside the company and reporting these disclosures. Lastly, this sort of ties in with the first suggestion, but make sure that you're constantly reviewing your anti-retaliation policies and giving them to employees and evaluating them, talking about them. You don't want them just sitting somewhere gathering dust and have someone say, well, I didn't know that I had to take it to the press because I didn't know that I could report within the company. You would really, I think Sai touched on this earlier, the best way to address these issues is for employees to take these complaints in-house.
Yeah, and if there's ways to show employees that even if there's anonymous reporting, you don't know necessarily who did the reporting, if there's a way to announce that there's been a report of something, we take it very seriously, this is what we're doing about it, and explain to the employees what you're doing and show that you care, it's more likely that employees will internally report in the future. And if you were to find things that, let's say, are like lower level of severity, and there was an employee involved who maybe is like more expendable or something like that, to actually show that you're taking actions somewhat quickly with regard to those sorts of allegations that you've investigated and found to be sort of verifiable. You can show people that you're taking actions. Now, obviously, if it's something much more serious or if it's with a high-level employee within the company, then there needs to be an investigation. You can't just kind of act out on things because that might implicate other issues like mandatory disclosure requirements under the FAR and things of that nature. So they can be more serious and should take more time. But still, if you know the employee who made the complaint, talking to them potentially and saying, look, this is what we're doing about it. We appreciate your input. This is great information. You know, you're the kind of employee we need to have around here. We have a high level of ethics, that kind of thing. Make them feel that it's appreciated and that you're bringing things to their attention and helping the company, and they feel like you're fostering that kind of culture. That's the kind of things that really pushes employees to feel that they can be open about these sorts of things. And like we said here, anonymity is a lot of times crucial to that.
And I don't know if this is a plus in favor of anonymity, but part of a whistleblower retaliation claim is proving that management knew that an employee made certain protected disclosures. And if they're anonymously reporting these disclosures, there's no way to prove that you knew it was them so it can actually help you in some circumstances. We sort of got into a little of this next slide, but what are different ways that you can manage employee complaints and make sure that they feel that they're being heard? First and foremost, you should, if possible, always get complaints in writing or at least in recorded form. That's what a hotline might accomplish. And you want to make sure that you respond to them promptly. If you're responding quickly, it makes it look like you take these complaints more seriously, and an employee is less likely to get impatient and take their complaints elsewhere. So many times I've heard employers talk about how, oh, well, that employee is just a gossip. It's not a big deal. They're just upset about so-and-so in the other office. I really recommend against taking this approach, because one minute it's gossip, but the next minute it's a reasonable belief that there's been a violation of law, and you really just want to avoid that sort of general approach to disclosures. The more thoroughly you investigate, you talk to other employees, you ask questions about what an employee is basing their belief on, the more likely you are to avoid liability. Especially when courts or third parties are looking at these cases, if the employer was investigating and really looked like they were trying to get to the bottom of this, they're more sympathetic to that employer. And also, if you're investigating and you find that there actually wasn't a violation, you essentially are giving an employee less of a reasonable basis to believe that there is harm going on. So suppose an employee believes that there's some sort of, I don't know why, but I'm on this environmental kick, arsenic in the water supply. If you look into it and test it and there's no arsenic in the water supply, the employee can't then come back and say that they had a reasonable belief, because you've disproved their belief. You also want to carefully plan your investigations and figure out who you really do need to talk to. So another element of whistleblowing is knowledge and timing. So if a supervisor ultimately ends up retaliating against someone, but they never knew about these disclosures, you can't prove retaliation.
Oh, and the other thing too to remember about the False Claim Act in particular and mandatory disclosure considerations is the action to be taken for mandatory disclosure in particular, it can't be negligence. Like if you were just negligent in doing something, that doesn't rise to the level of having FCA liability, so arguably it's not a violation of the False Claims Act. It has to be willful, knowing, or reckless behavior, and so, or an omission. And so if part of the investigation is determining whether you've met the standard, not just did something happen that sort of on its face looks problematic. It has to be a more fulsome analysis if it's a more serious issue like an FCA issue, because that can result in treble damages and much more serious liability potentially. And there's treble, so whatever the harm was times 3 plus I think it's $22,000 a year-ish, something like that now per violation. So every single invoice you submitted after the alleged behavior occurred, that can all. So there's a lot of things that go into it, and you want to be more careful about those sorts of investigations. That's not the kind of thing where I would just go off. But if there's something that's reported where an individual employee misbehaved or did something that violates not FCA but some other law or provision and somebody reported it, that's something where you might want to, if it doesn't hurt you, take action right away and quickly to show support and solidarity with the employees.
And just know your limits. Know when you have to seek outside counsel to answer some of these questions. We're going to go over the last couple tips in these next 2 minutes. One is keep your personnel files up to date. The best defense to a wrongful termination claim is a clear record demonstrating why discipline was necessary and why it had nothing to do with whistleblowing activity. You can also strengthen file management by having regular performance reviews, keeping written records of discipline or employee conduct. Just make sure that you keep things in writing and make it very easy to look back and make it clear, oh, it wasn't that we fired him for whistleblowing. We fired him because he hadn't come to work for the past 3 days or something.
And you got to be consistent. So that's the other thing that we find a lot is the person who's sort of disliked in the office misses a week without, telling anyone, or a couple days, and they not a week, but a couple days, and they fire them. Whereas the person who everyone loves in the office, something happens, they don't show up for work, they don't tell anyone, they're like, well, what happened? Oh, my car broke down and my phone went in the toilet or something, and I wasn't able to call anyone. And they say, okay, no problem. That sort of inconsistency with things can be problematic. So just...
I'll just add, whistleblowers really are often not very likable. They go against the grain. They talk about everyone's dirty laundry. They're unpleasant, but that doesn't mean they're not protected. So just be careful that your own personal feelings about certain employees don't cloud your employment judgment. Lastly, you want to make sure that in this world where emailing and information is so much easier to get out there, just make sure that you have proper protections in place, enforce electronic monitoring and acceptable use policies, and make sure that you have someone who's a chief information officer or a security officer who is charged with protecting data, especially if you're working on government contracts that might be more likely to have classified or sensitive information or personnel information. If you're responsible for other people's information, you have to take extra special steps to make sure that it's not getting out, especially when there are whistleblowers who are protected for making these sorts of disclosures.
All right, I think we're out of time. I appreciate everybody attending and everything. Here's our contact information. We had a couple questions that we'll get to offline. We'll be able to respond to people. So thank you again for attending everything, and we hope to see you at the next one. Thank you.